Welcome back. This is lecture video number 20. Today there's going to be a little bit of review at the start. You may recall in number 19, and I highly recommend you go back to number 19. Number 19 was principally about a decision from the Board of Veterans' Appeals, which in my opinion was a brilliant decision, that had 14 remands, 1-4, ranging from the mundane to grave substantive matters. The extrapolation from that particular decision is a proof, wide-ranging, that my general thesis that the VBA, Victor Bravo Alpha, claims people who handle your claims can't perform their job, don't have to perform their job, and that the remedial level at the Board of Veterans' Appeals, which in my opinion is not a court, when you get to that remedial level and the board tries to fix the shoddy work of the VBA, these remands go down and they are supposed to be reworked in an expedited fashion by the same people who got it wrong the first time. The board, when they send remands down, essentially takes out the crayons and in big print tries to explain to VBA Claims how to do its job. It is done in the simplest of terms, but understand at the same time, what does simple mean? There is a term in rhetoric called reductio ad absurdum, where you take an argument all the way down to a basely simple level. It's a form of ridicule as well. So it's used in rhetoric, public speaking. I'm not talking about that. I'm saying that sometimes the Board of Veterans' Appeals, with great skill, when it sends a remand down, or 1-4, 14 remands, tries in the most basic fashion to tell those employees how to do their job. It's as though there are no managers at these regional offices telling people how to do their jobs. I further explained to you that because the remands by law, remember, there is law and then there is CFR. 38 United States Code is Congress setting out the law. 38 CFR is the VA saying this is how we will operationally implement the law. So 38 CFR, Code of Federal Regulations, is binding on VA employees. So remands come down and they are expedited and they are in front of you when you have filed a claim. And the more remands there are, the more there are in front of you. And yet, VBA assesses its performance itself on how fast they can get your claim out of the barn and into your hands. You see what's happening? It is as though VBA Claims creates a pressure cooker for its own employees to turn out, and you've seen this phrase in other matters I have shown you, so please go back and look at these lectures. I use their documents. It is as though VBA Claims creates a pressure cooker for their own employees, stressing the only relief they can get is quantity, not quality. There's a conveyor belt. It's timed. The bonus is paid to employees on the basis of these management by objective standards, productivity. So we are in lecture 20. We have gotten to this point by using government documents. We're not exposing secrets. The remedy, easy remedy, is at hand, which is take the whole claims operation, give it over to Social Security, let it proceed under the Administrative Procedures Act with administrative law judges. Take all of these veterans law judges from the Board of Veterans' Appeals and bring them over to Social Security as administrative law judges. I have shown you a perfect opinion. I have shown you an outstanding detailed opinion. In parts, in its great detail, there's a high level of competence at the Board of Veteran Appeals among the judges, all right, the veterans law judges, and staff attorneys. It does not mean that I agree with their final decisions necessarily, but what I'm telling you is you can take all of them and make them administrative law judges over at Social Security, streamline the system, bring in due process, bring in discovery where you can see your entire file. Get rid of all this ex parte stuff. All right, so we're at lecture 20. Remember, I showed you this particular form for the Board of Veterans' Appeals. You have 3 critical choices that you have to look at. You have to decide, how am I going to submit this? And I showed you the seductive language, which said if there's a delay, it's your fault. If there's a delay, you did it. How long can the board take? I was in litigation, and the secretary, through Office of General Counsel, up at the Court of Appeals of Veterans Claims, a federal court, Article 1, federal court. Well, 10 years might be too long, but there's no rush. And that's tough. For the vet, that is tough. So even if you had the remand I showed you yesterday, which was expedited at VA, I have clarified the law. That expedited status wears off once it's down there again, the remand, at VBA. When it comes back up, you're not expedited anymore. This is rather amazing. And you have to refile at the Board of Veterans' Appeals as though you were coming back new. It's this system is in place before you were born. You have the 3 choices. Remember, any delay is your fault, not their fault. I want to talk to you today about human nature later on, but we're going to talk about the NW Cue Ball League. What is this? Well, I'm going to go into that after I take my usual short break. NW Cue ball, what is this? Okay, I'm back. We are at the stage where the decision went down in a remand with 14 remands. The incompetence is obvious. It goes back to Victor Bravo Alpha claims. You may think, logically, it goes back to the exact same crew that screwed up. No, it doesn't. National Work Q. NWQ. National Work Q. I call it cue ball. It's a sport. You're the ball. It is a computer system. I've briefly touched on this. That is supposed to take your claim, whether the original claim or the 14 remands this incredibly disabled Navy vet got. It takes anything that hits VBA claims and computerizes it. And it tries to make an efficiency system, which is to find the office with the present least work. There must be a celebrated algorithm to figure this out if VBA claims is full of remands and regular claims. So, what is the office right now, as you are looking at this, not when I'm speaking, as you are looking at this, what VA regional office or satellite of a regional has the least work? Because it will be different from the time I am speaking to the time you are listening. In fact, it may change every hour, 4 hours, every day. VBA employees know this. How much work are they supposed to do on your claim? Either original, or maybe your case was remanded back to VBA because of VBA's sloppy work. You have no clue. You have no idea where, and there's an office in the Philippines, you have no idea where your claim is being reviewed, either original or on remand. And remands are expedited. So cue ball was set up with what's called the best of intentions. I'm going to move something around here. In February of 2017, 2017, the American Legion put out an article exploring National Work Queue's impact on claims processing. American Legion, February 14, 2017, and the heading is Legion, legion.org. I don't want to take away from this image. So, VA going all the way back to about 2013, was saying, here it comes. This is the Veteran Service Organization talking. VA had this idea that they would be able to process claims in 125 days, 125. The VA will go to Congress and wave this flag. It's an old flag. that says 125. In fact, they could go with T-shirts that were only made up one time that say 125. It's their solution for everything. If you give us more money, we'll process these claims in 125 days. And everybody sits back and accepts this. It's a total fiction. But that's not the point. The point is that you're being bounced around on the queue. So the queue was supposed to help with this 125, you see? In mid-2015, there was a backlog. This is 2015, reflecting back on 2013. There was a backlog of 611,000 claims. 600,000 claims. Do you know what happens when you start finding the office with the least work? When there are 600,000 claims in a backlog? And that's not counting what's coming in as remands. Let's just think about this. So your claim isn't, if you're in Kansas, your claim isn't going to be worked on necessarily in Kansas at all. It could be by somebody up in Maine, maybe somebody in Alaska. But wait, it is electronic. Cue ball. They're all under the same pressure of 125. Do you understand? The American Legion was saying, as far back as 2015, and then into 17, wait a minute. Hold on a second. This means that a claim may not even be viewed by the same person as it goes forward. That means today, somebody from Minnesota regional office tapped it and said, I looked, put it back on the queue, and then tomorrow, least busy office tomorrow, somebody in Florida tapped it and said, I looked at it, put it back on the queue. And then the next day, somebody in California, you notice nothing is happening? Why is that? Because the first employee then got swamped by more, and the second employee got swamped by more, and the third employee got swamped by more. I have bounced around with claims. I didn't realize I was being poisoned over 4 years. Every base I was at was heavily polluted. So some of the things I have as a residual of that are pretty wild. So if I filed a claim as I discovered new things, I was being bounced around coast to coast to coast, everywhere. The old days. Do you remember seeing people with suitcases that would have all these different stickers from places they'd been? I was being bounced around everywhere with nothing being decided, but a lot of work done toward 125. And so I invented this term called cue ball. I was being cue balled. Everybody knew it. The employees knew it. So let's take a look at how did I find this out? VBMS notes. I have to take a break. I'm back. VBMS notes. You will not get them when you get your claims file. Why is that? Because they don't feel like giving it to you. Is it record before the agency? Of course it is. Is it an official record? Of course it is. What does it look like? Imagine ledger entries. Very short, dated, with the name of the employee and the office number they work in. All the offices have station numbers. Try and find them. It's a little difficult. That's on purpose. So you see these ledger entries, and you can tell where they are. And they'll have one line, maybe two, to the effect of, I looked at it and I thought about it. Next. Well, I looked at it and I thought about it. Well, I looked at it and I decided to send him for another CNP examination. And then the next one is, well, I just kind of looked at it to make sure that everybody else was looking at it. So you see, 4 pieces of work. One decides to throw in, because it looks good, a CNP examination, probably with an internist for a neurological injury, which case law has said, hey, it's a medical examination. Hey, I mean, why not an obstetrician? After all, it's a medical exam. How about a podiatrist, an expert podiatrist who works part-time for let's say, doing these things, and part-time for an NFL football team fixing ankles. So it's an absolute top podiatrist. Why not have the expert podiatrist opine on brain injury? Case law is that's okay. And so I'm waiting to see when they say a veterinary exam, because after all, there are a lot of similarities among mammals, which all veterans are. I mean, you can have nurses, nurse practitioners, physician's assistants, internists. All of them can opine about brain injury, nerve injury. So you get cue-balled all over the place. You want the notes. When you do your Privacy Act demands, which they will ignore, you keep going at them, reminding them, you want the VBMS notes, all of them. Now, I have talked to you about human nature. 14 remands, one case. How can this be tolerated? You are the problem. If you didn't file these claims, there wouldn't be any remands. You see? See how simple it is? You could still have all the employees, but they wouldn't screw up anything, because if you don't file claims, well, there it is. And if you did file a claim and you died, they could close it out. Death watch. So you're in cue ball. You didn't know it, but you are in it. What exactly does that mean? Time. Does it make them more competent? No, it does not. All right. So let's proceed from this one. Oh, we're back to this thing, to the board. The 3 choices you have to make. I've gone over this carefully. Carefully. The Navy veteran in the case I discussed in number 19 had an expert, excellent lawyer who went through every part of VBA's work. The result was 14 remands, but also, he got a very high rating from BVA, pretty much as a directed verdict. All right, now we're going to go into something else. Here we have, okay, Forum of Hate. ABA Journal, July 1, 2020. It was active at the board for 7 years using an official board email system. I want to talk to you about human nature. Remember, this is the law, Congress. This is the CFR. the board is not under the Federal Administrative Procedures Act. Okay? There was a forum of hate. What on earth does that mean? Short break. Okay, I'm back. Now, remember I've been telling you that there is in these proceedings no discovery, no cross-examination, no depositions, no getting affidavits from VBA employees, no federal rules of civil procedure. It is an ex parte procedure from VBA up into BVA. This shocks most lawyers. It shocked me. AI is used to fill out opinions per board annual reports. Subpoena demands were ignored in my cases. Board admin, not the judges, can issue baseless attack letters, and the board uses a mail drop. So when you send things to DC, it ends up in Janesville. Not a big deal. They should just tell you to send it to Janesville. What was the forum of hate? I was rather dismayed to read this as a lawyer of long practice. I was, how can I put it, absolutely dismayed to see that this could be happening. No, there are people who are lawyers who can be evil. I'm sure there are, as you know, generally. Lawyers who've been murderers and scoundrels and war criminals, etc. Human nature can prevail. What happened was, and you should look this up, I gave you the reference, Forum of Hate, the ABA Journal, American Bar Association Journal of July 1, 2020. The title was Disturbingly Inappropriate Emails. Disturbingly Inappropriate Emails. You can look this up for yourself. In 2017, here's another headline. The outfit was Concerned Veterans for America. I don't know what that is. No discipline for Forum of Hate undermines need for VA accountability. First act. According to Concerned Veterans for America, VA Board of Veterans Appeals administrative law judges, attorneys, and managers who were caught engaging in a forum of hate, FOH, had still not been disciplined or terminated over a year later. What were they talking about? Ooh, a number of subjects. Sometimes veterans were thought to be essentially scammers. Sometimes it was racial comments about other employees or about their appearance. It was utterly shocking. And I'm not going to go into the exact quotes because I think they are beneath the dignity of this lecture, but you can well imagine what it was like, and you can look it up and read some of these quotes. Human nature means that in any group of people, you will have bad apples. Courthouse News Service, Forum of Hate. I'm just taking a look at certain pages as I'm talking. DisabledVeterans.org. Veterans law judges removed. And on, and on, and on. They're not there anymore. Forum of Hate. I want to contrast that for a second. with the opinion that I showed you yesterday, where a veterans law judge went into extreme detail in an outstanding opinion to, in my opinion, basically take VBA apart. That would be the exact opposite of someone operating in a forum of hate. Here's what I'm saying to you. The extreme nature of something like forum of hate amidst a group of lawyers working at BVA does not mean that all of BVA was infected, or once it was found and removed, that anything was left of it. Well, you may say, but doesn't human nature say that if you catch 2 or 3 mice, that only indicates there's 10 more? I take a look at some of the board opinions and I come to the following conclusion. First, because they're lawyers. Now, I have had people on the clock being paid a lot of money in litigation engage in ancient rhetorical tirades against me, and I always found it amusing. Sometimes I would take notes because it might be really good. It neither excited me nor anything else. If you read some of the discussions of cases in law in Rome, they would say the wildest things. I have come to the point with Victor Bravo Alpha, VBA, that I don't think it can be saved. I don't think it can be retrained. I don't think that it should continue. And my solution is take it over to Social Security. Here's what I'm telling you. The lawyers who populate the Board of Veterans' Appeals are people. I do not think that the entirety of it is either infected or was infected by this forum of hate. I think there was an isolated pocket. I think it was resolved. I don't necessarily agree with the final outcome of Board of Veteran Appeal cases, but as I have shown you, they are also bound by the law, 38 U.S. Code. They are bound to respect 38 CFR, the VA's operational rules. They are bound to respect case law from superior courts. Now, I will tell you the glaring failure of Board of Veterans' Appeals. They cannot enforce their own decisions. This is a major problem with the structure, not with the people. Listen to what I said. This is from law and then CFR. The Board of Veterans' Appeals has no teeth. It cannot bite. It cannot strike back at VBA. VBA knows this. In my case, I had a Board of Veterans' Appeals decision, judgment, with remands, very serious remands. VBA refused to work on it. I had to go to the federal court, the CAVC, the Court of Appeals of Veterans Claims, and get a federal judge to start issuing orders. And only then would VBA work on it. BVA did not lift the proverbial finger to help me to get enforcement of a BVA opinion, judgment. You see? I was in an ex parte system. I was going through the system. I had a BVA judgment that was useless, which is why I own a domain called nodecisionmatters.com, because it doesn't. Get this through your head. This is not the individual veterans law judges. I wrote to the secretary and I said, this looks pretty dumb. It's your BVA. The VBA won't enforce a BVA judgment. Do something. I heard nothing. Time for a break. All right, I'm back. And I left off with the secretary declining to act. VBA had no power to do anything. Now, I want you to imagine you're in a U.S. district court, a federal trial court, and the judge issues an order, a judgment. And it says, do the following to one of the parties under the jurisdiction of the court. And the party refuses. So the other party says, now there's an order that says you have to do this. So do it. And there's no response, nothing. And so the other party then goes to the boss, if you will, of the party that has this order against it and says, hey, this guy that works for you is supposed to follow this order, make him do it. Because otherwise I have to go back to the court and ask the court to do something really bad to this. Nope. That doesn't exist in the VA. So to get VBA to do its statutory job on an expedited remand, I had to go to federal court to get them to do it. Hey, no big deal to me. It was a big deal. I had to write a long brief. I had to do statutory exposition and so forth, and case law. But it's familiar to me. It takes me a lot longer to try and do it these days, but I did it. And I forced VBA to work. So VBA can throw you into cue ball and bat you around. VBA can ignore you. I've shown you where they would get things and they would just kind of stack them up. I've shown you where a VBA gets caught taking decisions without even reading the medical files, gets caught by the IG, and then I've shown you a case in 2022 where they're caught by a brilliant and persistent veterans law judge. And I had to go to federal court to get VBA Victor Bravo Alpha to do its job. What kind of system is this? It is a system set up by Congress. Think about this when you vote. Think about all these things that you give up. You gave all of this up when you joined the military, when you were injured or got a disease, when you got out. You gave up all of these things to try and get the benefits, which are basically unemployment benefits, workman's comp. Does this system sound different from a simple claim at this point? Do you need a lawyer for this? When I showed you the decision yesterday, remember, lectures ago, I talked about reading comprehension. Legalese, like the decision yesterday, takes a lot of attention to write. A lot. It's not written to be read by amateurs. You may be a brilliant physicist. It doesn't mean you can read and understand yesterday's decision. You see? This is why you need a lawyer. A longer break this time. Okay, I'm back. Hopefully I can finish this today. Sometimes I have to do some things in order to continue. And I'm using a cell phone camera, plugged in, power, and I can walk away for an hour and come back. This is a college level course. I couldn't do this as a stand-up, any of these episodes. So I'm grateful to YouTube, and this is for you, because the way I view it is, all of you who took the oath are effectively part of my family. Brothers and sisters, and you will be here long after I am gone. And hopefully this will help you. My conditions worsened a lot many years after I left active duty. As I said, I didn't realize I'd been environmentally poisoned. I didn't know. Of course, I've also said that the entire spirit of military service is Valley Forge. Go back to my early videos. None of it matters. The mission is first. I was always second, third, fourth, whatever. I was a volunteer back many, many years ago when Vietnam was on. I was in ROTC. I was commissioned in 1973. Pilot training was basically halted, Air Force. And so I was what? Waitlisted. I was in the reserves. I was 1973, not very popular to be in the military. Never went anywhere near Vietnam. So I went to law school. And I thought that pilot training would open up, and then I found out that, well, not for you. So there I was. I did my active service as a judge advocate. Would I have volunteered, knowing what I know today, that I would be on my PCS basis potentially environmentally poisoned? And the answer is yes. I would have done exactly the same thing. Why would I have done that? As I explained, I had been through East Germany, East Berlin, when it was under Soviet communist hardball rule. I spoke German. I understood it very well. I understood what Russian communism really was and what they intended for this country and for most of you listening. I knew what gulags were. I knew what midnight raids were. I knew what disappeared people were. And that's what they wanted to do here. If that sounds overly dramatic, trust me, it was overly true. Was it worth it? Absolutely. Absolutely. Let's get into this particular part of the lecture. This is the second major homework. I'm told that when you do handwriting, it makes it pop. There it is. I'm going to take a short break before I continue to speak. Okay, so this is another case. But this, I'm not going to show you the long case report, but I think you should read it. Here is the citation. The case is Saunders versus Wilkie. This is the citation. You can go on Google, and all you need to put in really is Saunders versus Wilkie. Wilkie was the secretary of VA. And so cases where VA is involved and you're up in the federal court system are always styled with the Secretary of VA. He is technically the defendant, but only technically. Where did this case go? It went to the U.S. Court of Appeals for the Federal Circuit in D.C. So if you are living in Kansas, I like Kansas, or Florida, or Minnesota, or California, and you have gone through claims, denied, gone through Board of Veterans Appeals, denied, gone through the Court of Appeals for Veterans Claims, denied, your next step is to go to this court, the U.S. Court of Appeals for the Federal Circuit in D.C. Federal Circuit in D.C. hears cases on appeal from just about all the administrative agencies. You know, all these alphabet agencies of the government. It's a busy place. You don't get appointed to this court unless you're really good. I mean, as a jurist. These are top-notch people. They have a lot of law clerks. They get cases from the VA. And the reason I'm showing you this case is because it was, in my opinion, distasteful what the VA had done. And all right, so what had happened? Saunders is basically the appellant. We'll call Saunders the plaintiff. So Saunders brings the case through Saunders' lawyer. If you want to read grandiose stuff about military, go to this. This is what we're talking about as nuts and bolts for you, for your claim. I think I'll use this pointer. First off, Saunders filed her claim in 2008. This case is being resolved in 2018, 10 years later. What is going on? Why does it take so long? I can understand if the case involves IBM, Apple Computer, General Motors, big corporate interests. This is a veterans case. A veterans case. This is an individual human being who has served the United States. Why does it take 10 years to get here and have a decision? The Court of Appeals for the D.C. Circuit is not wasting time here. All right. The claim was denied and she filed a nod in 2009. This is the old days. It took 9 years for the case to get to the Honorable Federal Court of Appeals for the D.C. Circuit. The claim: simple, vanilla, ordinary, oatmeal, in-service knee deterioration with diagnosis of physical injury. So what's the first thing the VA did? Now, they're represented by the Department of Justice, government employee lawyers. 10 years. She has to have a lawyer to be here, Saunders. The government gets the free ride on Department of Justice. You see where this is going? And where is Saunders? Is Saunders even in D.C.? When you file a brief before this court, or any federal court, it's a big deal. There's a lot of research. There's a formula for presentation. The first thing the VA did was attack the jurisdiction of the federal appellate court. Well, that's not a very smart thing to do unless it's slam bang. Remember what I said about jurisdiction of cases. It's limited by statute. And look here, 38 U.S. Code, Section 110. See also 38 CFR, Section 4.1, etc. The issue here, what about pain? P-A-I-N, pain. In 1991, in this case, Shafrath versus Derwinski, then the secretary, at the CAVC, who's reporting books, volumes if you will, although it's all digital, are called Veterans Appeals, VET app. This is the citation. You can look this up. This discussed pain from a service-connected elbow injury. So the CAVC said pain counted as disabling. Pain counted as disabling, but due to an underlying diagnosed injury. So Saunders has a knee injury. Here's what happened. The Federal Circuit had to come in Saunders. And you know what it said? It said that pain has to be considered by VBA. Pain has to be considered by VBA. And in fact, it's like a separate claim. I mean, it was pretty obvious. But the VA, VBA, BVA, under their interpretation of the statute, and the CAVC all said, no, 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 even though there was a case in 1991. What do you think this court thought of that? What do you mean pain isn't going to be considered? This is what the actual case looks like. This is what a report, United States Court of Appeals for the Federal Circuit, this is what these opinions look like. This is all preamble. It's pretty standard. It tells you case name, number. It tells you who's appearing on behalf of. And I want you to understand something. Here we have a law firm in Washington, D.C., argued for claimant appellant, right? And look at all the other people. National Veterans Legal Services Program, Washington, D.C. I don't know, but that sounds charitable to me. But do you know? They're all in D.C. Well, if you're in Kansas, how do you get these people? Because the VA sits back and says, Commercial Litigation Branch, Civil Division, United States Department of Justice. Hey, tell us how it turns out. Doesn't cost us anything. How did Saunders get these people? Now, the judges all know this. Same issues. So I want to show you basically continuity of this. Melba Saunders appeals from a decision of the United States Court of Appeals for Veterans Claims. Okay? Pain, bilateral knee disorders. Okay? The Veterans Court, CAVC, erred as a matter of law in finding that Saunders' pain alone, absent a specific diagnosis or otherwise identified disease or injury, cannot constitute a disability under 38 U.S.C. 110. The Veterans Court erred, they were wrong, as a matter of law, not fact, law. We therefore reverse the Veterans Court's legal determination and remand for further proceedings. This tells you when Melba Saunders served on active duty. When she left, her exit examination showed swollen knee and hip joints and bone spurs on her feet. So what did she do? She filed a claim in 1994. The VA, and I'm going to show you something, regional office denied Saunders' claim because she failed to report for a required medical examination. Now, Saunders did not appeal that decision. I wonder why. Time for a break. I'm back. They can set you up at VBA for a CNP examination. And one of their favorite games is to do it hoping that you won't show up, because then they can close the file. It wouldn't matter if you were in a coma in a hospital. They set up a CNP, you didn't show up, case is closed. It's your problem. You figure it out. I've seen this in case after case. And I've seen veterans say in their Board of Veteran Appeals decisions, say to the board, no one told me. No one told me. I had back-to-back CNPs thrown at me after a stroke. What was the purpose of that with an internist? What was the purpose of back-to-back CNP examinations, two, after a stroke? You know what it was. Hey, if he doesn't show up, we close everything. If he doesn't show up, we close it. Now, I was not comatose from my stroke. As you can see, I'm a little bit computer savvy. And I would get these bizarre emails from the CNP examiners, two different vendors, not the same one. So I showed up for both. I arranged driving and I showed up for both. I don't read minds, but I know. In my heart of hearts, my opinion is VBA thought about sending me for a third and a fourth and a fifth. Do not suppose that they're going to tell you if you are scheduled for a C&P examination. It is a playbook stunt. A playbook stunt to close the file. 125, you didn't show up, goodbye. That's how they can earn their bonus. I discovered, and I forced them to admit, that letters they said were sent to me for other matters were never sent. Couldn't find any record of it, even though they said it was sent. I have a VBA decision on two issues from October of 2022, which to this day, VBA has refused to serve on me. I got it by other means because I know how to do that. I got it by other means. So I would write to VBA and say to them, oh, I see you have this decision. Please send me the official copy. Silence. A little while later, I wrote to you and said on this date, and I'm saying it again, copy attached of my earlier letter, I'd like you to serve the decision on me, the full decision. Silence. 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 I wrote to them maybe 5 times. Silence. I've told you how that works. I had a hearing with a hardworking, highly experienced veterans law judge on these issues. And she did not have a copy of the VBA decision in her file during the hearing. That's not a defect. I explained why. That they simply refused to serve it, even to BVA. But I included it in my filing. So this BVA judge, veterans law judge, was looking at the official filing up and through VBA. And my response was simply, you see, this proves that they are both deceitful at VBA. This is a proof. They are both deceitful, which means they do things to hide them, and corrupted, which is one of the things I routinely say about VBA in my cases. So, now you know. Required medical examination. Keep a calendar. I have handy a combination of erasable boards. This is from my legal practice. And because I keep up with the times, you know Post-it notes? Well, I'll tell you what. Post-it notes makes these gigantic Post-it notes. They're huge. And they are poster boards. You write on them with magic marker, ballpoint pen. And here's what you must do. This particular one I'm looking at is really chart size. It's huge. It's 25 inches by 30 inches. You can write on it again, magic marker, ballpoint pen. Get one of these. Don't use a grease board thing, because that you can smudge that and it goes off. Get one of these Post-it easel pads, E-A-S-E-L-P-A-D. I have to take a break. Okay. Post-it easel pad. And what you will be writing down on it, from the top going to the bottom, is the sequence of when you do things. But you will be adding one more thing. The sequence of what you do can go on the left side. Divide the paper in half, basically, with a line. The sequence of what you expect your opponent at VBA to do will go on the right side. It's a sort of a balance sheet of time. Your actions go on the left side. Their actions and expected actions go on the right side. So let's say you file on January 1st, the first day of the year. You'll make a note to yourself under your actions on the left side. By January 30, you will start saying to them, notify me in writing when my C and P exam is. You will do this in writing. You will do it on January 30. Then on February 1-5, you have a note to yourself. Write to VBA about your C and P exam. And you will include a copy of the first note you sent to them. And you will say, basically, I sent you this note on January 1-5, or February 1, January 30th, and I'm just reminding you that I sent it, and by the way, this is my second note, and here's what it says. Do you see why? Because off to the right side of your sheet, you will be looking for and be suspicious of when your CNP exam is scheduled, if at all. Now, I want you to understand something. I am not your lawyer. If you don't understand by this point that you need a lawyer, go back to the very start and re-examine these videos. What I am telling you is a standard kind of litigation calendar tickler, if you will, that lawyers use. And you can buy it with Post-it notes. And you can post this thing up on the wall anywhere convenient to you. It won't smudge away. It's paper. And you can look at it and see it. It's not like a little notebook that'll be lost. Okay? Now, your lawyer will be doing exactly this. Get a lawyer. Do you see what I'm doing? I'm telling you simple things here, but they end up being so critical because look what they did to Saunders. You fail to show. What is Saunders supposed to do? So she didn't appeal that decision. Maybe she couldn't. In 2008, Saunders filed a new claim for bilateral knee disability and for foot issues. Well, the RO treated this application as a request to reopen the prior decision, granted the request. Why? Do you think she ever really got notice? Do you think she ever got notice? So the RO treated this application as a request to reopen because the RO saw the whole file and saw maybe what wasn't sent. Granted the request and denied both claims on the merits. Boom. Case closed, now on the merits. See, maybe there was nothing in the file that said she'd ever been notified of the exam. Or maybe when she got out, she was moving around. And they sent a notice to an address that she wasn't at for the past 6 months, 8 months, a year. Do you see where this is going? Even if you tell them I've changed address, why do you think they have to actually book or log that in? There's a lot more to this case, isn't there, than just pain. Short break. I'm back. Okay. So in 2008, she files. The file is kind of like whitewashed and denied. So in 2009, Saunders submitted a notice of disagreement. So she starts the appeal process. And she cites the diagnosis when she got out. Okay, she says, well, I was in the military. I still have pain. The RO denied this claim in February 2010, citing a lack of evidence of treatment for a knee condition. Of course, when she got out, her knee was swollen, et cetera, et cetera. So Saunders appealed this decision to the Board of Veteran Appeals. During a 2011 VA examination, apparently Saunders showed up. The examiner noted that Saunders reported experiencing bilateral knee pain while performing various activities. The examiner found that Saunders had no anatomic abnormality, weakness, or reduced range of motion. The examiner is looking, but doesn't seem to find anything. Do you see any mention of x-rays? Do you see any mention of x-rays? The examiner also noted that Saunders had functional limitations in walking, that she was unable to stand for more than a few minutes, and that sometimes she required the use of a cane or a brace. Joe Namath used to play football in his prime for the New York Jets when they won the Super Bowl, one of the first ones, wearing an incredible knee brace system. His knees were shot. He'd been injured playing football, I think it was for Alabama, in one of the world's great collegiate football programs. No, I didn't go to old Alabama. I am not Crimson Tide. Okay, so the examiner finds this. The examiner diagnosed Saunders with subjective bilateral knee pain. But he can't find any anatomical problem. But we see no evidence of x-rays. Anyway, we know when she got out, she had swelling, etc. We know that she had pain. Well, the VA said, okay, pain could not be provided as a diagnosis for Saunders' knee condition. And remember, they can't find any anatomical problem. Pretty good without x-rays. So the VA said, now go back and look at this again. Is there any pathology? Here's an example. You might look at somebody's knee and say, well, it looks good. It's not, the bone isn't swollen. The bone isn't sticking out. Maybe there's an ACL. It's a big ligament in the back of your knee. Maybe there's an ACL partial tear. They're not finding anything. You can diagnose an ACL, it's a football injury, or a tennis injury, or actually walking down the stairs, or loading at UPS. You can diagnose that by feel, pretty much. So, there just weren't any visible diagnostic conditions. So Saunders appealed to the board. The board is bound by the law. Okay? The board is bound by the law. Pain alone is not a disability for the purpose of VA disability compensation. Why is that? There was no pathology. The examiner didn't provide any pathology. What's really going on here? Oh, we have this rule. We know it doesn't mean anything. We know, quite frankly, that she has, or she had when she left, swollen knees, etc. But that's not good enough. She was examined. There's no record of x-rays or anything else. No MRI. Did it even exist? X-rays did. What was the level of competence of the examiner? Time for a break. What was the level of competence of the examiner? So the Veterans Court took it, and they went through the law. She asked for a panel review. That's where the court, not just one judge, but 3 or more of the court members get together and take a second look. So they said, we'll do that. We'll take a look. And, in looking at it, they come to the same conclusion. It's called en banc, or in French, en banc. So she's turned down twice at the CAVC, effectively. And then they come down. One of the first questions is always, is there jurisdiction? And the court resolves that under 38 U.S.C. it has jurisdiction. This is highly technical, very relevant legalese. Does that remind you of the writing of the Veterans Law Judge from yesterday's 1-4 remand opinion? It's necessary. You need a lawyer. So there's a dispute on jurisdiction. And this goes on and on and on. This is just jurisdiction. Let's get down to the meat of the decision. question is the legal questions of whether pain alone constitutes a disability, okay, and whether the holding of Sanchez Benitez, I showed you that earlier in my little digest, was merely that the board and Veterans Court resolved Saunders' claim based solely on the holding of Sanchez Benitez. Okay, legalese, foreign language for civilians. Okay, we come down and boom, this is going to be the holding. Pain can constitute a disability under 38 U.S.C. 1110. The opinion before this court is never lightweight stuff. Never. Okay? It goes through the mechanical test of how to claim. Okay? And they turn to the language of the statute. Look at all these cases. This is what these cases look like. We're just on Saunders versus Wilkie. They refer to the ratings regulations. I've gone through that with you a little bit. See the case law? 38 CFR again, 4.1. We've talked about that. We're into Allen versus Brown. In view of the statutory purpose to compensate veterans based upon degree of impairment of earning capacity, this is workman's comp. That's what it's about. You can be in a wheelchair, as some veterans are, and be highly productive. You know that. Time for a break. Because now I want to really end up today's lecture. I have to. We find that disability in Section 110 refers to the functional impairment of earning capacity, not the underlying cause of said disability. You can be in a wheelchair, as some of our fellow veterans are running around on prostheses for lower legs, literally running. What is their earning capacity? Has it been diminished by the loss of feet, of hands, etc.? It's not about pain alone or discomfort. It is about, is your earning capacity diminished? And if it is not, then your rating is 0. Unless, as I have shown you, the law says you get this rating for losing, let us say, a foot and a hand, an eye, if you're totally deaf. Okay? There is a presumption. And the statute will tell you that for certain kinds of injuries. But all this particular vet Saunders had was pain in the knees. No statutory coverage. There's no presumption. She was diagnosed with pain. She kept trying to make the point. Here's the holding. Okay? It took 10 years to get there. Let's wrap up for today. It goes on and on, as cases will, and they talk about, I don't know. It's important to lawyers. It's not important to you. Okay? Now, the wrap-up. Saunders took 10 years to get to this court. If we add up from the time she was first denied with this allegation of you didn't show up for the exam, she took 20 years to finally get a recognition of her disability, which was manifested by pain. I want you to think she had excellent lawyers. That part of the case still takes 10 years. In D.C., how many vets filed with a similar type of injury? These are concussion injuries. These may be brain injuries. Okay? There is a concept called referred pain. Referred pain. The injury is at, let us say, a lower part of your intestine. And it comes from a concussion injury because your military vehicle was wrecked, blown up, slid on the ice into something, who knows. But you have this injury. And you think the pain from that injury should be at that site. Well, indeed it may be. But it may also have caused referred pain up in your shoulder. How can that be? There is a famous study and a famous article. I'll talk about the article for a second. A dentist in it's Australia was writing for an Australian dental peer-reviewed journal, and he wrote an interesting article. And he said, when people come in with jaw pain to me, I do a very careful examination of the jaw around the area of the tooth. And here is what I have found. The pain at this location in the jaw, which the patient thinks is related to the tooth, and indeed it is right by the tooth, isn't being caused by the tooth. It's being caused by nerves down in the torso. It is referred pain. Referred pain. Follow? The concept of referred pain has been commonly known really since ancient times. So, if you read an ancient medical text, it will say, if you have a pain in the following area, don't forget to check this and that. It could be the liver. But wait, the pain is in my upper back. It could be the liver. Don't ignore this. And so what this dentist is saying is, I always triple check before I do an extraction to make sure that that's it. Well, how do you do that? Oh, well, I put a painkiller by the tooth. Yeah? And if they still have the pain, it's not the tooth. Oh. You mean like oil of clove, a little bit of anesthetic? Yeah. And so then we try to figure out, and I refer her to other doctors to try and figure out where this pain is coming from, because it could be coming from nerves in the torso, upper chest. It could be coming from a different organ. It is referred pain. This woman had pain. There was no doubt about it. She was complaining about it and filed a claim. It took 20 years. How many vets during those 20 years, that 20-year time span, how many vets got stepped on who didn't have these lawyers, who got sent for examinations maybe they were never notified of? You remember, when she was notified for the second time, she went, which would indicate maybe she wasn't notified for the first. See how this works? You can't fix VBA. Shut it down, give it to Social Security, save billions of dollars, take all the administrative law judges, transfer them over to Social Security, take the veterans law judges, transfer them over to Social Security as administrative law judges, and you have all the due process that you could possibly want under the Administrative Procedures Act. How many vets got the same treatment as veteran Saunders, who had the ability, through excellent lawyers, to go to these federal courts in Washington, D.C.? Could you do the same? I'll leave you with this. Remember, you are in, when you file a claim, here's where you are. No discovery, no cross-examination, no depositions, no getting affidavits. All right, that's it for today. Now, get your own lawyer. Please get a lawyer. I am not your lawyer. I am not giving you legal advice. Sometimes I will give you some practical solutions, but I am not giving you legal advice. I've shown you some excellent lawyers. I don't give out praise easily, but when I see it, I commend it. The forum of hate is gone. The BVA veterans law judges can be taken right over to Social Security as administrative law judges. I've shown you an outstanding piece of work. I've shown you a perfect opinion earlier than that. I don't necessarily agree with their decisions. They all know that this is going on. Get your lawyer. Well, I'm going to pay for this over the next few days, physically. All right, next one is interesting.